Welcome to Policy on Demand. I'm Scott McCandless. The tax world is watching and waiting for decisions on 3 cases before the Supreme Court, which could have a significant impact on U.S. tax law. And today we're going to get a status report and some insight into what lies ahead from Pat Brown. Pat, thank you so much for being here and for joining us.
It's great to be here, Scott.
So we're dealing with 3 cases. 2 of them fall into one bucket and the third stands on its own. The first, Relentless versus Department of Commerce and Loper Bright Enterprises versus Raimondo. Both deal with something called the Chevron doctrine, which has to do with the deference given to federal agencies.
Right.
And then the other case, Moore v. United States, technically deals with undistributed foreign earnings, but there's this specter of a possible realization of tax question that's out there.
Right.
So let's just, taking all 3 at once, are these cases coming up in conversations with companies?
Yeah, so they are, and they're coming up quite a lot, Scott. And it's interesting. So, of course, the Moore case was argued first. And before the Moore case was argued, I think it was argued in like December. There was a whole lot of, there were a lot of articles in the tax press. Is this the end of the income tax, et cetera? Interestingly enough, after the oral arguments in the Moore case, I think people sort of came away from the oral arguments thinking that the court was unlikely to do major damage, sort of rip down the edifice of the income tax. And only after that did attention turn to the Chevron cases, which, as you know, are not actually tax cases, but they have a lot of tax implications. So as we come now towards the end of the court's term, we're expecting decisions on all of these cases very soon. I'm hearing a lot more about potential application of the Chevron doctrine. If the court reverses or significantly narrows that, what is that going to mean? I've heard less about Moore recently, but obviously we'll get a decision on that as well. So, more to come.
Sticking with Chevron, maybe out of the gate, focusing on that, how might the tax legal landscape change if Chevron were changed?
Yeah, so the Chevron doctrine, which, by the way, is celebrating its 40th anniversary this year. So the Chevron doctrine, as you noted, deals with a deference that is given by courts to administrative agencies. And in a nutshell, what the Chevron doctrine says is, to the extent that that statutory text is silent or ambiguous on a question, courts will defer to the interpretation given by administrative agencies in their regulations, okay? So that is, again, in a nutshell, the Chevron doctrine. Since the Chevron decision 40 years ago, the court has, I would say, expressed some sort of misgivings or some desire to maybe claw that back a little bit. And so we've had, over the course of the last 30 years, we've had development of what's sometimes referred to as the major questions doctrine, which is essentially a limitation on Chevron to say, look, maybe we'll defer to the administrative agency, their interpretation of a statute, but we don't believe that Congress would leave major questions completely to the discretion of administrative agencies to just fill in these gaps. So to the extent those sorts of things are unaddressed, we as the court system feel the right to come in and offer our interpretation of that, not necessarily deferring to administrative agencies. If the Chevron doctrine is completely reversed, what you would then, or significantly narrowed, what you will have is more from the judicial branch essentially saying, when it comes to the interpretation of a statute, there's what the administrative agency says, but to the extent either court or the judges on a court have a different interpretation that they also believe to be reasonable, they may have less deference to the administrative agency. So where we sit today, where the Chevron doctrine applies, courts are more or less obliged, I would say, to say, I'm going to defer to the administrative agency's interpretation unless it's unreasonable. If that standard gets narrowed, you're going to have more of the specter and more of the possibility of administrative agencies putting out regulations, but judges coming along and saying, I understand you interpreted it that way. I just don't read the statute that way. And so therefore, I'm going to adopt a different interpretation.
So you've mentioned that agencies and their interpretations would be affected. Let's talk about the 2 specific tax agencies or regulatory bodies. What about Treasury and IRS? How would they be affected?
Yeah, so Treasury and IRS have indicated they don't expect significant impact on their processes or their regulations as a result of these cases. I'm not entirely sure I buy that. One thing I would expect to see is, to the extent that the Chevron doctrine is narrowed, more, frankly, ink spilled by the Treasury Department and IRS in regulations, offering the rationale for their regulations. So again, the whole purpose of the Chevron doctrine is to say, courts need to defer to administrative agencies, effectively unless the administrative agency's interpretation is considered unreasonable. Mm-hmm. If that standard gets narrowed, there's more of an onus on the administrative agency to say, this is why my interpretation of the statute is the best interpretation of the statute. It's the most appropriate interpretation of the statute, as opposed to merely, there are multiple interpretations, but you have to defer to my interpretation as the agency. If the agency no longer has that essentially deference from judicial decision makers, there's now more of an onus on them to provide more of an explanation. So for people who are already complaining, Scott, about preambles and regulations are getting longer and longer and longer, it wouldn't surprise me if they continue to get longer as Treasury and the IRS potentially feel the need to say, let me explain to you, let me walk you through my analysis as to why my interpretation of the statute is the interpretation that you, the court, should follow.
Sure, that makes sense. If we could turn to the Moore case, and this deals with international tax provisions, what effect might this ruling have on tax provisions such as GILTI or Subpart F?
Yeah, and it's a great question, Scott. So of course, the Moore case itself, the Moores, the plaintiffs in the Moore case, that case dealt with Section 965, a provision in Subpart F, of course, part of the TCJA, and the tax on undistributed earnings from the time period predating the TCJA. And so the case itself is about a provision in Subpart F. Now, there's been a lot of speculation, of course, there was when the court decided to take the case, that the court wasn't really as focused on Subpart F as they were potentially on taxes on unrealized income, potentially at the individual level, or wealth taxes, or things like that. So it will be surprising to me, based on the oral arguments, if the Supreme Court goes right after Subpart F and right after GILTI. But to be sure, it is certainly a possibility that a very sweeping Supreme Court holding here could essentially say Subpart F and GILTI, because they are taxes on income before it is physically realized by the taxpayer, that is to say it's a tax on a deemed dividend, not an actual dividend, that is not permitted under the 16th Amendment. Now, that would be a surprising outcome, to be clear. A lot of the speculation is that there will be some sort of a narrower holding, maybe one that is not in the Moore's favor, but puts a marker down for the Supreme Court to say there is a realization requirement in certain circumstances or in certain fact patterns or whatever, something that basically puts something down to sort of circumscribe Congress's ability to do broader things in this area. But we obviously will have to wait for the decision.
Sure. Fascinating. Can't wait to see how this comes out. And we should know by the end of June. So.
We should, absolutely, yes.
It's fascinating. Thank you for your insights, Pat. Appreciate it.
Yeah, absolutely. Great being with you, Scott.
As well. Monday Briefing will be back next week, along with Congress, whose key focus will be the appropriations process for FY25 government funding. And the Senate may schedule a procedural floor vote on the House-passed tax bill. And for those wanting to weigh in on the Ways and Means tax team's process, comments will be accepted by email through October 15th. In addition, Senate Finance Committee Republicans are said to have created 6 working groups on the 2017 tax reform provisions scheduled to expire after 2025. We're following this process closely, so stay tuned to Policy on Demand for more. Thanks for watching, and take care.